In this video, I want to explore the difference between a claim for lost income under a common law claim as opposed to a human rights claim, and there are extremely dramatic differences. So in the common law claim for wrongful dismissal, the court will set a notice period, whatever that may be, and then determine what income the employee would have earned in that period of time, less any monies that the employee did earn or should have earned by mitigation of employment. So that's the typical framework of a claim for wrongful dismissal. And added to that claim are all components of income that the employee would normally be entitled to for that notice period. So that's pretty well standard fare stuff. Human rights is much different. A human rights claim for lost income is based on something called the make whole concept. That is, put the employee back into the position that he or she would have been in had the unfair conduct, such as termination due to whatever violation of human rights law took place, whatever income that person would have earned in the passing of time. And the claims for lost income under human rights, because of that difference, are incredibly different from a wrongful dismissal claim. First of all, the length of service has no bearing. The position held has no bearing. The tribunal will look to simply the fundamental question of what would that person have earned had the wrongful action not taken place. And the claims for lost income in human rights law are nothing but gargantuan. There are claims for up to 10 years lost income, 5 years, 4 years. The claims are just dramatically different. And even there may be a claim for reinstatement, and absent reinstatement, there may be a claim for loss of future income where reinstatement is not ordered. So I will provide a link to the summary of the cases below showing the awards that have been made for both lost income to the date of hearing and also claims for future lost income where reinstatement has not been allowed. So again, these are dramatically different from wrongful dismissal cases, and regard should be had to how the case should be argued, whether it should be a wrongful dismissal claim or a human rights claim. Now, I add one further note, and that is Ontario law. Unlike any other jurisdiction in Canada, you can sue for a human rights remedy provided there is another companion claim being made. So in Ontario, you can argue that there should be a claim for lost income under human rights and or alternatively a claim for wrongful dismissal damages. Now, you should speak to your lawyer very carefully about that because it's not as simple as I have suggested in the summary, because you want to be careful as to which claim is pleaded first and which is the alternative claim. But again, these are dramatic differences. There's also a big difference with respect to employment contracts and human rights. I will discuss that in the next video. Thank you.